Okay, Section 44-53-2110 of the bill talks about what the department does in regard to issuing registry identification cards to patients, and it talks about the information that's contained: name, address, date of birth, date of issuance, a random alphanumeric identification number, photograph, just technical things in regard to what the department will do in establishing a registry identification card that can be possessed by a patient who has qualified to receive cannabis for medicinal purposes. Section 44-53-2120 talks about reciprocity, I guess. It talks about in terms of a valid registry identification card or its equivalent that is issued pursuant to the laws of another state, and talks about the circumstances in which that recognition is recognized. That's going to be addressed, I think, in the Senator from Spartanburg's pharmacy amendment, essentially to modify or curtail that so as to, as I understand it, constrain it to this program to those that are issued in South Carolina. But I'll let the Senator from Spartanburg talk about that when it's time for his amendment to be discussed. Also talks in that same section, in subsection B, giving registry identification cards to designated caregivers and setting forth the qualification for being a caregiver. And of course, that means what it implies, which is an individual who could stand in the stead of a patient and receive and go to the dispensary or a pharmacist and get the medical cannabis. This relates obviously to situations where you're either dealing with a minor or you're dealing with a patient who is homebound and is not ambulatory and can't get to the dispensary or to the pharmacist, him or herself. But that section deals with how do you become qualified to become a designated caregiver, and how does the department evidence that somebody is authorized to be a designated caregiver. Section 44-53-2140, again, it starts out by saying, under what circumstances can a department issue a registry identification card to a person? And it starts with the very fact a physician has to submit that written certification to the department that certifies that the person has got a qualifying condition. And again, this emphasizes that nothing happens, no cards are issued, no cannabis is purchased by a patient until that physician, in a written certification, after going through an exhaustive list of what he has to do or she has to do to examine, certifies that this patient has a qualifying condition and that they could benefit from medical cannabis. They also see further provisions there in regard to conditions precedent to a department issuing a registry identification card. One thing I would point out in that same section, 44-53-2140, subparagraph C, and this is something that I was talking with my friend, Senator from Charleston, Senator Sen, the other day about. It reads as follows. For a new patient applicant not to include a renewal, the department may not issue a registry identification card to a patient applicant who is between the ages of 18 and 23 years unless two physicians who have performed in-person exams and verified the patient applicant's debilitating medical condition submits a written certification to the department on behalf of the patient applicant. And the Senator from Charleston, Senator Sen, raised some good questions last week in regard to, is that violative of the Equal Protection Clause? And my response was that it is not violative of the Equal Protection Clause because individuals aged 18 to 23 are not a suspect class as defined by the Supreme Court of the United States. Therefore, this particular provision doesn't have to withhold or bear up under strict scrutiny. It only has to bear up under the rational basis test. In other words, is there a rational basis that serves a legitimate state objective in treating this class of individuals differently? And I think that this particular provision does meet that lowest standard of review under equal protection by satisfying that rational basis test, because I think that if you're 18 to 23 years old, given your terms of development, given your degree of maturity, I think that there's a rational case to be made for the fact that as to that class of individuals, 2 written certifications is a burden that is not unreasonable. Now, that's something that we can debate, and if others think that this is too much of a burden or do think that it's violative of equal protection, willing to look at an amendment and take that up. But I can tell you that based on my analysis of this, not a suspect class, rational basis test applies. There is a legitimate government objective here, and I think this is a rational way of achieving it. So that's my little argument there. All right, section 44, 53, 2150 talks about designated caregivers can only serve 1 patient unless the caregiver is a facility licensed by the department. And what's meant there is, I guess, is some sort of a group home or a nursing home or some sort of facility where there may be numerous individuals who qualify or have medical cannabis cards or authorized to receive medical cannabis by their physician. In that context, a facility could have more than one patient. In other words, they could operate and act on behalf of the various individuals in the facility.
Senator from Charleston, Senator Gibson, what purpose do you rise?
Unanimous consent motion.
State your request.
Just to make an announcement with the senator holding the floor, I wanted to just make an announcement.
So you're recognized to make an announcement.
Wanted to let
without objection.
Want to let the colleagues know that Robert Beauchamp is out in the lobby. This is the governor's nominee for the chair of DHEC. So if you have any questions, he'll be out in the lobby. I'd like you to meet him. Thank you.
Senator so notified. Senator from Beaufort.
The next section is section 44-53-2170, which says, until 90 days after the department begins accepting applications for registry identification cards, a copy of a patient's valid written certification issued and printed by the physician on tamper-resistant paper within the previous year must be deemed a registry identification card for the qualifying patient. In other words, while the department's in the process of putting into place its system of issuing registry cards, with those cards evidencing one's right to obtain medical cannabis from a pharmacist or dispensary, until that system is up and running, the written authorization signed by the physician serves as that registry identification card for that gap period while that's being developed by DHEC. Section 44-53-2180 states that a qualifying patient must notify the department of any change in his name, address, telephone number, or email address, or if he ceases to have a debilitating medical condition. So this goes to the strict monitoring of this program, in that DHEC records, which are fully accessible by SLED, pursuant to this bill, have to have accurate information in regard to that qualifying patient, in regard to where they're living, how they can be contacted, what their telephone number is, what their email address is. So there's a burden on the part of the qualifying patient to make sure that the department has up-to-date information as to their whereabouts. And again, if this is violated, the penalty is a revocation of that registry card. And let me just make this one point. A lot of these nuts and bolts and mechanics and how the system would work, I would say 2 things. First of all, I had the advantage of looking at the 36 other states that had medical cannabis laws and looking at what they did in terms of setting up a program, and then inquiring of officials in those states, as I have, what's worked. Did they ever have to amend something? Was there something that was provided for that had an unintended consequence? So this bill and all these nuts and bolts are a product of those inquiries on my behalf and the subcommittee's behalf. They're also, what's in here is the product of what DHEC said it wanted. This is laid out. DHEC had carte blanche. I said to DHEC, I want you to come up with language that if the General Assembly decides it wants to empower physicians to authorize use of cannabis by patients for certain conditions, what would the program look like? How would you tell me how it could be set up in a way that enables you to effectively administer the program. Every single thing that DHEC requested is in this document. There's nothing in this document that DHEC suggested should be done that isn't in here. So I want to make that point, that on the front end, and this was several years ago, but it continued over time, DHEC was continuously engaged in their ideas solicited and what they proposed incorporated into this bill. Section 44-53-2190 talks about DHEC's obligation to establish a secure web-based verification system. It talks about what the verification system must contain. Section 44-53-2195 makes it clear that medical cannabis product information received and maintained by the department is confidential and is not subject to public disclosure under the Freedom of Information Act. This is a confidential list and cannot be accessed by the public. You've got various healthcare privacy concerns associated there. Section 44-53-2200 talks about the cannabis products that a patient can be authorized to get can only be in 14-day increments. Again, that's more conservative than in a lot of other states. For instance, Mississippi, who passed their law last week, again, by a 10-to-1 margin in the House and the Senate, allows for a 30-day authorization, and the Mississippi bill allows flower to be smoked. And the Mississippi bill has 24 conditions, not 12. So it's more liberal in those respects than our law, but this is our law, okay? And our law limits the amount that a patient can get at any one time to a 2-week supply of cannabis. Section 44-53-2210 creates various safe harbors that if you are a qualifying patient who has been issued a registry card by DHEC, or if you're a designated caregiver that has been properly issued a registry card by DHEC, that those individuals, the patient and the designated caregiver, cannot be then arrested for possession of medical cannabis if that medical cannabis has been authorized by a doctor and is in that 2-week allowable amount, and if it's not, it's a safe harbor saying it's not illegal for them to possess medical cannabis under those circumstances. If you have a card, you've been authorized to have it. Section 44-53-2220 states that it is unlawful for a physician to certify cannabis products to any person for the purpose of smoking or burning. And then the next subparagraph says it is unlawful for a cardholder to possess cannabis in plant form or to smoke cannabis or use a device to facilitate the smoking of cannabis. And again, this is a concession that was made to law enforcement, I want to say a couple years ago, when I asked SLED and law enforcement what their concerns were about this bill. In fact, Margie Bright Matthews, senator from Colleton, was the one who interacted with them. And the number one thing, the concern they had was they did not want individuals to be smoking or burning leaf to consume medical cannabis. And so that was incorporated into the bill to make it unlawful to smoke marijuana. Section 44-53-2230, this will be of interest to those who are concerned about how can law enforcement hold to account somebody who is operating a motor vehicle while impaired by cannabis. And this particular section, talks about, first of all, in that section 44-53-2230, paragraph A, subparagraph 1, it says that an individual cannot undertake any task under the influence of cannabis if doing so would constitute negligence or professional malpractice. In other words, there is no safe harbor here for doing things if you have a medical cannabis card. You can still be negligent. You can still commit malpractice. Those same rules in regard to what a prudent person in reasonable actions in ordinary circumstances, those negligence principles still obtain. There's no special harbor created for those that are taking cannabis even legally under this program. Also states that an individual cannot operate, navigate, or be in physical control of any motor vehicle, aircraft, train, or motorboat while under the influence of cannabis. So again, this particular section is going to be of interest to those of you who want to dig into have we done enough to enable law enforcement to hold to account individuals who operate vehicles illegally under the influence of cannabis. And so that's the section you may want to direct amendments to if you have concerns in that regard.